Hi, Dr. Gans. For my independent research project, I decided to research the trafficking of endangered or protected species, also known as wildlife trafficking. What drew me to this topic is the fact that this is a global billion-dollar a year industry that profits on the abuse of all kinds of wildlife. I hope you don't mind. I have my notes page here, so I might be looking over every once in a while. Some examples of activities that qualify as illegal wildlife trade or would be considered illegal, an illegal aspect of wildlife trafficking is illegal logging of protected forests to supply the demand for exotic timber, illegal fishing of endangered marine life for food purposes, poaching of elephants to supply the demand for ivory, harvesting parts of animals such as rhinoceros horns to supply vendors with medicinal materials. These activities and the people who engage in them push endangered species, which are already at a much higher risk in our society, even further towards extinction. In addition to this, illegal trade of protected species negatively impacts countries' natural resources and local communities that might otherwise benefit from legal or safe, sustainable trade of these organisms or tourism associated with these organisms. I think this is a particularly interesting aspect of wildlife trafficking or trafficking of endangered species. I think this is a consequence of these activities that is not often brought up in conversations that we have about wildlife trafficking or at places like animal rights conventions, which is a venue where I think conversations about this topic would be frequent. I don't think the human rights aspect of it is something that is talked about a lot, but these local communities that are being essentially manipulated, they could profit off of these creatures, but they're not. They're losing that opportunity because of greed and capitalism. Federal enforcement against those who violate these wildlife protection environmental laws date all the way back to 1900 when Congress first passed the Lacey Act. This is one of the first pieces of legislation that deals with the trafficking of protected species. This piece of legislation, as well as subsequent statutes associated with wildlife protection, addressed the problem of inadequate state regulation that was unable to contend with the potential profits that individuals could receive from the interstate commerce of this trafficking. Now, this points to an issue that is associated with state regulation all the time, is that there's a lack of uniformity. There's a lack of communication across state lines. There's a lack of agreement on what this trafficking is, or what even constitutes an endangered species, or what constitutes taking an endangered species. So this inadequate legislation at the state level allows a lot of people to manipulate the system and get away with unjust actions. And so The Lacey Act was a piece of federal legislation that identified those inadequacies and addressed them by creating a federal standard for what was expected. So the Lacey Act makes it a federal crime to violate the laws of any state, tribe, or foreign country, and then move or trade the wildlife across the U.S. borders. Now, in addition to addressing inadequacies within the state, it also addresses inadequacies. Pardon me, it has been a long week and I am misspeaking. It also addresses inadequacies at the international level. As we see with any sort of bureaucratic situation, red tape leads to poor communication, leads to, once again, a lack of uniformity across different countries. So this ensures that even if something is not considered illegal in the U.S. Pertaining to our environmental laws, if it is illegal, explicitly illegal based on the laws of a foreign country or a tribe or a different state, it has to be respected and it has to be treated as an illegal act in this situation as well, which is important in unifying the country. Additionally, this piece of legislation referring to the Lacey Act was recently expanded to include plant species, which is important because a lot of legislation doesn't, or when people think of endangered species or when they think of trafficking of wildlife, they often think of exclusively animal species, which is just a portion of it. There are hundreds, thousands of species of plants that are endangered and abused by the system of wildlife trafficking and the people that participate in it. As I said earlier, illegal logging practices, that was a big concern that was addressed by this recent expansion of the Lacey Act. Another environmental law that has to do with the criminal enforcement of wildlife trafficking is the Convention on International Trade in Endangered Species of Wild Fauna and Flora, also known as CITES, which is what I will be calling it because that is a very lengthy name. This was created in 1973 as an international agreement between 179 countries to regulate the global trade of these protected species. As I was saying just moments ago about the Lacey Act, CITES was another way that we were attempting to unify the globe, unify international efforts to create an international standard to be enforcing environmental laws. The two main agencies responsible for implementing and enforcing CITES provisions in the United States are the U.S. Fish and Wildlife Services Division of Management Authority and Division of Scientific Authority, as well as Office of Law Enforcement. A really crucial part of this convention was the founding of the ICCWC, which stands for the International Consortium on Combating Wildlife Crime. The ICCWC represents a collaborative effort between a bunch of different international agencies, including Interpol, the UN Office on Drugs and Crime, the World Bank, and World Customs Organization. When I say that, referring to the ICCWC, was formed to increase the rate of prosecution and the severity of the punishment assigned to individuals that have been caught and proven to be involved in smuggling or poaching of endangered or protected species. It also has increased the presence of law enforcement in developing nations where these sorts of illegal activities surrounding wildlife trafficking are often taking place. When it comes to arresting and prosecuting individuals involved in these activities, law enforcement officers with the U.S. Fish and Wildlife Service and with the National Oceanic and Atmospheric Administration, which are both two agencies that do enforce environmental laws associated with wildlife trafficking, they have often been compared to law enforcement officers associated with narcotics. This is because of the techniques they use in pursuing individuals. For instance, controlled deliveries of contraband wildlife, followed by anticipatory warrants, often result in overwhelming evidence against consumers of illegal wildlife. This is a quote from the Fish and Wildlife Service. It essentially means that law enforcement officers pursue low-level individuals that are at the bottom of the totem pole, metaphorically speaking, and they are much less careful than suppliers would be, and they are much less prepared for law enforcement than suppliers, and so it's much easier to catch consumers of illegal wildlife with lots of evidence. And they use this overwhelming evidence to convince the defendants to cooperate with law enforcement and divulge information on their suppliers, because that's the real target of government action. Because when it comes to deterring illegal trade activities, convicting suppliers has a much greater impact in the long term than convicting consumers. And that makes sense. It's the same with narcotics, and that's why that's a comparison that's often made, is because they work from the bottom up, because the big ticket item is at the top of the totem pole, but it's much easier to climb the totem pole than it is to jump straight to the top. Silly analogy, but anyways. So statutes in the U.S. that relate to trafficking of protected species include the Lacey Act that I mentioned of 1900, and then the one that most people probably think of when they hear endangered species, which is the Endangered Species Act of 1973. The Endangered Species Act was the first time that we really compiled a list of species that were considered endangered. This is another fault of the legislation at the time. There was that lack of a national standard, and this helped establish part of that. It also prohibited any taking of listed species or the trade of protected wildlife. So the act provided civil and criminal sanctions for violations of its provisions, and it also provided definitions of different actions that would be prohibited under those provisions. Some of these actions include the taking of an endangered species, possessing, selling, or transporting any species that was unlawfully taken, and then another thing that people might not think about that's prohibited under the Endangered Species Act is attempting to commit any of these crimes, soliciting or attempting to solicit another person to commit these crimes. And while some may argue that this is too light of a penalty, the statutory penalty that is outlined in the Endangered Species Act for an individual that violates the provisions cannot exceed $50,000 and cannot exceed imprisonment of 1 year. There are several examples of major criminal enforcement proceedings I could talk about. but one ongoing effort by the U.S. Fish and Wildlife Service, aided by the U.S. Attorney's Office, that I found particularly interesting in my research is known as Operation Crash. So Operation Crash is it has to do with rhinoceroses. The word crash is a term for the herd. The term crash means a herd of rhinoceroses, and the goal of this operation was to investigate and prosecute individuals involved in the black market trade of rhinoceros horns and other protected species. Now, all species of rhinoceroses are protected under the U.S. law, and some, such as the Sumatran rhinoceros, are even considered critically endangered. Some, such as the black rhinoceros and the Sumatran rhinoceros, are considered critically endangered. So this is a very high-risk organism, and there is a lot of legislation that exists around this organism at an international level. But as I was saying, in the U.S., all rhinoceroses are protected. This operation, referring to Operation Crash, has led to the arrest and successful prosecution of many major players in the industry surrounding the illegal rhino horn trade. One successful arrest and prosecution court case that occurred in 2014 due to efforts associated with Operation Crash is known as the case United States versus Lee. This is the case of an individual named Zhifei Li, and excuse me, I'm not sure if I'm saying that right, but I did try my best. This individual owned a business named Overseas Treasure Finding, located in Shandong, China. This individual was an active participant in the black market rhino horn trade, and since his arrest in 2013, he has admitted to several environmental crimes. The horns that he is responsible for smuggling across international borders were shipped off to factories where they were carved into fake antiques. These antiques were then shipped across the globe and resold at an incredibly high markup, giving Mr. Lee a very impressive profit. Even portions that were discarded during the process of forging these antiques, those were used and sold for medicinal purposes. So he made a profit in several ways. He did operate in the United States, and he was the quote-unquote boss of 3 different antique dealers. On one of his trips to the U.S. in 2013, he met with an undercover U.S. Fish and Wildlife Service agent in a Miami hotel room. And unfortunately for Mr. Lee, he purchased 2 black rhino horns for the sum of $59,000. As I said earlier, the black rhinoceros is critically endangered. And he was soon after arrested on federal charges, and he pleaded guilty on a slew of charges. These included conspiracy to smuggle, conspiracy to violate the Lacey Act, 6 smuggling violations, 1 Lacey Act trafficking violation, 2 counts of forging wildlife documents, and excuse me, that was it. 2 counts of forging wildlife documents, that is it. Within the process of these court proceedings, he also confessed to organizing and facilitating the smuggling of $3 million worth of rhinoceros horns, which equated to 30 raw rhinoceros horns from the U.S. into China. He made roughly $250,000 on just one forged antique. So yeah, he had a very successful black market business. And on May 27th, 2014, Jae-Fung Lee was sentenced to serve 70 months in incarceration and pay a fine of 3.5 million US dollars, as well as I can't think of the word, surrender, as well as surrender a few of his rare Asian antiquities from his personal collection. For the sake of saving time, I won't go into many other cases, but there are several names, such as United States versus Wirtz or United States versus Braley. Both of those involve protecting fisheries. And then the cases United States versus Rob Roy McInnes or United States versus Andrew Zaraskis are both cases involved with safeguarding protected species. I received most of this information from the Fish and Wildlife Service. I got some from the United Nations Office of Drug Crimes and some from the U.S. Justice Department. Thank you for your time. Thank you for a lovely quarter. I'm sorry if this was a little bit rambly, but finals week has been very stressful, and yeah, I'm not used to presentations this long, but I really enjoyed your class, and I learned a lot, especially in this project, but throughout the whole quarter. So thank you. I appreciate you. Have a lovely summer.